Hi, good afternoon, everyone. This is Rajiv S. Khanna from the law offices of Rajiv S. Khanna, PC, immigration.com. Today is May 9th, 2019. This is our bi-weekly community conference call, which we've been skipping for a few turns because of incredible busy times. The size of our RFEs, appeals, it's a lot of turmoil these days, getting cases processed and meeting all the deadlines. So we've been trying to take care of all that, and at the same time keep providing services to the community as best as we can. I'm back here today, so we should be able to deal with the questions that are posted quite easily. No problem. When you logged in, you would have heard that this is not an attorney-client relationship call. This is merely a community service. Let me start first by going over the couple of questions only that I think are frequently asked questions. One is about how to deal with the fact that I've got an H4 going and I want to travel and an EAD going on with the H4. So basically, I'm putting my mind back to the time when the frequently asked questions, etc., were published by the USCIS. This is what they had said. If you have a change of status pending, like H1 to H4, and an EAD pending, and you leave the USA while everything is pending, you will have to refile the EAD when you come back, and you can only come back after visa stamping. So if you leave while both change of status and EAD pending, reapply for EAD when you come back on H4 visa. And this is the question Dhruv Parikh had, the person who posted this, said wife's H4 change of status and I-765 EAD filed concurrently. Can she travel outside, get H4 visa stamping done, and reapply separate EAD again? Yes, she can. You don't have to withdraw anything. You can let the government know that she has traveled and that the old application should be considered to be abandoned, which is not a problem. So yes, you can certainly do that. I just also want to add on to it, what if you already have an H4, you are on H4 status, and you have an EAD request pending and you travel? The government said it could delay your EAD a little bit, but that's acceptable. So just to round up the frequently asked question, if you have H4 change of status and EAD both pending and you travel, come back and reapply for the EAD. You can't use the old request. But if you're already on H4, EAD is pending, you can travel and come back. Any follow-up question on this? *5. If you have a follow-up question, press *5. Okay. Oh, there is one. All right. Let's go to that question. This is from Florida. Florida, go ahead, please. Florida. Hello.
Yes, Rajiv. So thank you. You have answered the question.
Okay, good. Excellent. My pleasure. Okay, so let's go on to the next frequently asked question. This is about somebody who's got a 485 based EAD. AX 341 says, apparently their first part of their question is probably not frequently asked. The second part is, so I was attending to this frequently asked question part. So if you have an EAD, can you work at 2 jobs? And the answer is, I don't see any problem with it, because all these EADs, whether it is H4 based, student EAD is a little different, but H4 based EADs and 485 based BS based EADs, they allow you to do whatever you want. But remember, if you are the primary on an employment based petition and you are using that EAD to work at more than one location, the only question is, do you intend to work at your green card job on a full-time basis when you get the green card? As long as that exists, there is no problem. And the jobs can be dissimilar. I mean, for all, let's say you're a software developer, but you have this great real estate opportunity and somebody is giving you a job in real estate and you want to do both. I don't see any problem with that. *5 if you have a follow-up question on this. *5. Okay. Since I'm already dealing with AX 341's question, let me also get to his previous question, which says I've been working for an H1B for an IT company at a client location. Employer filed for PERM in Jan 2019. They'll file for the I-140 on PERM approval. Wife is Nepal born. Priority date is current. What is better, filing I-140 and 485 together? Well, that's your lawyers can advise you best, because if the I-140 is strong, there is no problem with the payment of wages, ability to pay. Go for a concurrent filing. I don't see why wait. Second, when can the application for ED and advance parole be filed? Only when the 485 is filed. It can take anywhere from 4 to 6 months, maybe more, to get these applications approved. Once EAD is approved, can I work for any other employer using EAD? I answered that question. Are there any constraints on the type of job? I also answered that question. There is no constraint on the minimum salary either. Are there any potential risks of working on EAD for a different employer? Only that you must maintain the intention to join the green card sponsoring employer, whether it is the original sponsor or a subsequent sponsor that you've joined based upon filing a supplement J using AC-21 portability. As long as you have the intention to join them upon approval of the green card, you are fine. Star 5 if you have follow-up question. Star 5. Okay, I think I had only two questions I thought were frequently asked. Let me double check, and then we can go in the order that we have questions received. So the second question is, unlawfully present in the US on a valid F1 visa for over 18 months from 2005, but left the US voluntarily, want to apply for a B1, B2 visa. Is there a chance to be readmitted? There are two separate questions here. By the way, there was a lawsuit filed this is not for this case, but just for your general information. You might already know this, but using against the USCIS using their August 8th memoranda saying that you can't, we'll consider you to be unlawfully present if you violate student status. Those have been stayed by a federal court in North Carolina, and that's a nationwide stay. So they can't apply that law to keep you out. Nevertheless, for this one, it's a little different, because even if you took a 10-year bar, I'm not sure it would even be applicable, but let's say it was, then by 2019, that 10 years is over. So unlawfully present is not a problem. But remember, B1, B2 visa is a very weak visa. It's all discretionary. If governments, if US consulate thinks, well, we have no reason to believe he's going to come back, he was illegal before, they can deny the B1, B2. That's a separate issue unique to B1, B2, F1 type visas. If you came on an H1 or an L1, the fact that you had overstayed and then stayed out for more than 10 years, that should be no problem at all. So it's the nature of the B1, B2 that can cause a denial because of a past visa violation. Star 5 if you have a follow-up question. Star 5. So you can certainly apply, make sure that you state all the facts truthfully, but I don't think it's going to be easy. Next question is from Mienjo66. Wife wants to bring her younger sister who's divorced and above 21-year-old. Our combined income is $250,000. You really don't have any special options unless the sister is very highly qualified and can fit under any of the employment-based categories. Based upon family, if she applied for her sister and your wife is assuming she's a US citizen, it would still take 13-14 years for the process. So there really is no special option unless you want to have her invest $500,000 and you want to loan her the money, which might be a possibility for her to do an EB5, a green card. That still would take 3-4 years to get here, but it is one way to do it. Other than that, except for her own qualifications, I don't see any shortcuts. Star 5 if you have a follow-up question on this. Star 5. Okay. So next question is from Kaushik. My LCA was applied 3 years ago. My employer's wage level was $165,000. But every month you got more than that every month. So I also got hike from the client starting this year. My employer started paying me $60,000 per year now. I'm going to apply extension this year. Can we apply the LCA with wage level 2 now? Absolutely. In fact, this is a big problem. If an employer wants to apply for an extension and they want to do it under wage level 1, I almost always refuse to let them do it because it sounds unreasonable that what is a level 1 wage? Level 1 wage is when somebody is still learning the ropes. They are just out of school. They may or may not know everything about the profession. They have a degree. They have the knowledge, but they don't have the practical experience yet. So typically less than a year's experience is level 1. But if somebody has worked with an employer for 1 to 3 years and then they want to apply again as level 1, I think that's unacceptable. So yeah, you must apply as level 2. I don't see any issue. And I think your employer needs to consult with a lawyer if they don't have their own lawyers and have all their questions answered. I personally don't see any problem with this. But remember, whatever you do, always be truthful with the government. No games, straightforward, keep it simple. That's why I'm saying it may be a good idea for your employer to consult with a lawyer. Have them talk with their own lawyers. Have them sit with them and make sure all their questions are answered. I personally think it's fine. *5 if you have a follow-up question. Okay. So we already did the next question. This was about the Nepal bond. Now we are at question number 8. It's Shai Katir. I've applied for H1B through some employer last year. Application was picked up in lottery. I went to visa stamping, got to 21G, and now the case got denied. Another employer can do my transfer. Well, I don't see how, because government is taking the position if you are in the USA and you don't receive change of status and your case is revoked, you're still considered to be subject to the quota. If you are outside USA and you don't get a visa stamping, you're the first time arrival and you're applying for the first time, you don't get an H1 visa stamping, they say that we still consider you to be subject to the quota. You can try. I think government has a misreading of the law and it should be challenged, but their policy was as I described. Okay. *5 if you have a follow-up question. *5. Okay. So next question is about somebody who has applied with cross-chargeability in EB3, but they might get a divorce. So how does this work? Well, I have to really, this is a tertiary issue of law, which is probably not written down anywhere, not that I can remember. I would have to review various sources. But typically, unless you are separated or divorced, cross-chargeability can still go on. The fact that you're having some difficulties in the marriage does not by itself take away your right of cross-chargeability. If you get divorced before the interview, they should deny your application. This should be researched. I'm very hesitant to give you a definitive answer. This should be researched, but my legal common sense tells me that if the divorce or separation occurs before the adjudication of the 485, it can be a problem. *5 if you have a follow-up question. *5. Okay. Let's go to the next question. This is somebody who got a green card, employment-based green card in 2005, and then after 12 years they're back again and they're applying for a green card again. Can they use the priority date from the old green card which they had surrendered? And my best guess is no, although it is definitely worth trying. Why? Because the regulations that came out on January 17th, 2017 made some changes in the priority date carryovers that can be argued on your behalf. It might work. So it doesn't hurt to try. I would suggest you try. Is my old I-140 priority date still valid? I just answered that question. Government used to think, and they still probably do, that upon surrender of a green card, everything associated with that green card goes away, including the priority date. But I would argue against that based upon the January 17th, 2017 regulations. *5 if you have a follow-up question, *5. Okay. So Arjun G says, received biometrics appointment for May 7th, 2019 to my sister's address in Bay Area, California. I'm currently working in India for an Indian subsidiary of a US company. Can't go to USA. Need to reschedule. Now, rescheduling and all, because I don't do it myself, my team members, our colleagues take care of all those details. I don't know everything about it, but I can give you my guess. Reading the appointment letter, I've been asked to send the original form and check a box to reschedule. Will a FedEx letter request to my sister requesting to reschedule ask my sister to... No, you have to make that request directly yourself. It doesn't need to go through your sister. And I'm not sure they'll allow you to request a specific week. At least I'm not aware of any such provisions. My sister will be out of USA from June through July. How do I request a change of address to India address? You don't need to do a change of address to India address. I'm not sure if that you even can, because you have a 485 going. You have to have, I think your lawyers can receive all information. So you can maybe have the lawyers file a G28 that makes them eligible to receive all your notices, even though they should be getting them. But even in the capacity of your representative, in fact, they should be able to do it. Can I walk in to USCIS Center for fingerprinting? To the best of my knowledge, as long as you have your fingerprinting notice, even if you prepone the date, usually application support centers will accept that. *5 if you have a follow-up question, *5. Okay. Then we have, this is question number 12. I am in US on H1B with no unlawful presence time. This is immigrant 1990. I filed for my adjustment of status based upon marriage to a lawful permanent resident. That's a green card holder. So he's gonna go, it's interesting then. Previous question asked about walking into the ASC before the date of your appointment. And this person said, yes, I'm going to do that. And the application support center said, you can do that. I don't think there should be any issue. They've been doing that for a very long time. Although I'm always doubtful about their current procedures. If you have already verified, I don't see any issue. Also, my main question is, I'll be doing my H1B transfer to a new employer, premium, and then plan to go to India and return with new I-797 and old employer's H1B visa stamp. My concern this time is, will my AOS petition be considered abandoned? Well, if you have, here is the problem. I have to have your lawyers review the regulations, and there might be some nuances that apply to your case. It used to be under the old Cronin memorandum that if you travel outside, you must have a pre-existing visa stamp and you must be coming back to work for the same employer. Now, what if you have a visa stamp from some other employer, petition from this employer, and you are re-entering on visa stamp of the old employer, but coming back to return to the same employer who processed your petition? I think that should be fine. But because the regulations have changed, it is a good idea to have that specifically looked at. That is this going to be a problem? If I come back on some other employer's visa. See, it's coming back is not the issue. How it interacts with your 485 and EAD. When you traveled out, you didn't have an advance parole, but you did have an H1B visa stamp, but it's not from the same employer who sponsored you. It isn't so much that you can or cannot travel. It is what effect does that kind of a non-employer or non-petitioner visa have on your ability to travel without advance parole? I don't think I can give you an answer definitively. I can give you a guess. I think it should be no problem. But if you want to be either very conservative, wait until you get the advance parole, or if you want to confirm it with the government through their customer service line, which is always unreliable, you can try that. *5 if you have follow-up question. *5. Okay. So Shaniel says, my perm was approved in 2016, I-140 filed in 2017, I-140 not approved. 6 years are over. Last year, my employer filed for extension for 1 year based on perm. This year, they're saying it can't be extended. They are wrong. They are absolutely wrong. You can get a 1 year extension still, and you can get it unlimited number of times. Once your I-140 is approved, then you get 3 yearly extensions. So you can definitely get 1 year extension. Okay. *5 if you have a follow-up question. Neelu says, a question about premium processing for EB2 I-140. Employer says it's okay for me to pay. So she wants to, or he wants to do it to avoid uncertainty with the government policies and shutdowns, corporate mergers and acquisitions. I think it's a good idea anyway. And plus, by the way, you are slightly misinformed about the rules. The rule is not that you can retain your priority date after 180 days of I-140 approval. That you can retain anyway. The moment your I-140 is approved, you can retain the priority date with any employer. But after 180 days, you can also retain the right to extend your H1B beyond 6 years based upon this employer's I-140 and extension being filed through any other employer. That's the only right that becomes yours after 180 days. Transfer of priority date remains your right the moment the I-140 is approved. I personally don't know of any downside of premium processing in your case. *5 if you have a follow-up question. *5. Okay, let's go on to question number 15. Child is on H4 about to age out, applied I-539 for transfer to F1. So if F1 application is still in process, can the child continue to enroll in the university? I don't believe so. Because, see, well, they can go to school on H4, and what they are doing is they are continuing to go to school on H4. They are not going to school because their F1 is pending. So as long as the H4 is valid and the school says go, it's fine, it's a go ahead, you can continue on the H4 while the F1 change of status is pending. See, I don't know when they are aging out. If they are aging out relatively early, you would have to transfer to B2 or file a transfer to B2 and keep applying for extensions of that, even if the old B2 is pending, unless the F1 is decided. So yes, an intervening B2 seems to be a necessity if there is not enough time left on her aging out or his aging out. *5 if you have a follow-up question. *5. Okay, let's get this question. There are 2 questions. I'm sorry, I didn't notice that. Let's go with the one who logged in first from California. So, California, go ahead, please. California.
Hi, hello, Rajiv. This is a follow-up to the previous question regarding the I-140 premium processing.
Right.
In the early part of this conference call, you mentioned intent to continue with the same employer. Well, like once you get a green card, you should stay with the employer because the goal is to permanently be employed with that employer. So does that kind of
let me interrupt you for a moment. What I was referring to was using the EAD while the 485 was pending. This is a different situation. This is where you have an I-140.
Right. Right. Yes. So in general, intent, meaning if you, after 180 days are complete after approval and you go, they are not going to question your intent.
No.
That
No.
you got premium processing so that you could quickly get the approval and then
Right.
you could quickly leave. That's
I
not
don't
something
see.
that
I don't see that as a problem. Can it be theoretically brought in? Yes, any kind of question can be brought in. But the most important thing is that the intention you have when you file the I-140. In fact, there are various indications in the regulations where an I-140 can be filed even if you have left the employer. So I'm not sure it is that clear-cut a case that government can come after your intention. But still, as a matter of defensive planning, it would be a good idea to have your intention straight the date you file the I-140. After that, if you change your mind, that's entirely your prerogative.
Okay.
All right.
Okay. Thank you.
Good luck, sir.
Thank you very much.
You're welcome. Okay. Let's go on to the next raised hand, which is from New Hampshire. New Hampshire, go ahead, please.
Yeah, hello, Rajiv. So my daughter is on H4 and she's planning to apply for undergrad in Canada. So if she gets a seat in Canada, can we apply for her 485 just in case our dates get current, and can we apply for her 485 while she's studying in Canada?
Well, this was not a related question. Nevertheless, today we have a relatively easy schedule, so I'll answer it. I was only asking for follow-up questions. But first of all, in order for somebody to file 485, they have to be physically in the United States in proper legal status. So if she has an H4 and she's in the US, she can have her 485 applied and then return to Canada to continue studies. I don't see any issue with that. Mm-hmm. So yeah, it can be done, but have a discussion with your lawyers to figure out the details.
Okay, thank you.
You're welcome. Okay, so let's go on to the next question. This is from ARX1122 of a valid H1B from employer A. I had two companies simultaneously apply for a transfer. Employer B got an approval. C got an RFE. I really want to join C. It's taken over a year to get an offer, then a transfer approval. I'm going to join B first. Employer A is a very hostile situation right now. Okay. Once I join B, can C still respond to the RFE? Absolutely no problem. So even if you join B, C can easily respond to the RFE. And if the C case gets approved, you can join C and leave B, also no problem. I don't see any ramifications here. *5 if you have a follow-up question, *5. Okay, there is a follow-up question. And or maybe this one is already done, or maybe not. I can't tell. I think this one is already done. I'm asking once more. I think I had an old hand up. Any follow-up question on this? Press *5, please. Any follow-up question? Okay. No question. Let's go on to the next one. Satish says, I have a valid I-485, a 485 based advanced parole. I need to go to India for 10 days on a business trip. So if my H1B stamping is delayed or denied, can I come back on AP? And the answer is yes, you can. I don't see any problem with that. Our clients have done that all the time. *5 if you have a follow-up question on this. *5. Okay. This question is from Delaware. Okay. Yes, Delaware, go ahead, please.
Sir, if the H1B is with, in my case it got approved, but if the H1B is pending, my friend in same boat, his H1B is still with the USCIS for approval. Can he travel while H1B is
well, if it's an H1B extension, transfer, or an amendment, yes, he can travel. But if it is a change of status,
It's a transfer.
yeah, no
It's
problem.
extension, sorry.
Yeah, he
It's
can
extension.
travel. Once the transfer is filed, he can travel as long as he has a visa stamp on his passport when he gets back. He can come in using a copy of the receipt notice of the pending case. Shouldn't be a problem.
No, he will be using the advance parole while entering into the country back.
There is a problem with that. I'll tell you what the problem is. I have to look at the regulations. I just mentioned that under the old Cronin Memorandum, which has now been put in the regulations, it used to be that you had to come back and work for the same employer who sponsored you. Otherwise, you were not on H1, you were on EAD. Okay? In order to revive your H1, you would have to then go and get a visa stamp and come back using that. So let their lawyers look at it. Travel is certainly possible. Only question is when they come back and go to the transferred employer, are they still on H1 or are they on advanced parole, EAD? So you have to figure that part out.
What if he continues to work for the same employer?
Then there's no problem. If he continues
transfer.
to work for the same employer and then the transfer is approved and he goes join the next employer, then it's fine. Only rule was that when he comes in using advanced parole, he continues to work for the same employer.
Though the H1B is pending during the trial.
That is
right?
no problem.
Okay. Thank you, sir.
Good luck. Okay. So the last question today is Monica has posted, my cousin came here on a visitor visa. They gave her only 1 month stay. I saw Monica had sent me a copy of the visa also. I think the visa is good till like 2029, something like that. It's a 10-year visa. What your relative got was the stay of only 1 month. Now the question is, because that's what they asked for, the immigration people at the border said the invitation letter says only 1 month, so they won't give 3 months. Is there a way to extend the stay now? And the answer is yes. File Form I-539 and you can ask for 3 months stay extension. Give a reason why you're asking for it. As long as the reason is genuine, I don't see any issue why you can't do this. In the old days, if they did not want somebody to extend their status, they used to make a notation on the I-94, no extension, no change of status allowed, or something of that nature. I don't think they do that anymore. You can double check, take a printout of your I-94. I don't know of any procedure that can put any endorsements like that on the I-94. So the short of it is that yes, you can try. You can try for an extension and the form is I-539. I-539. Any follow-up questions on this? *5 if you have a follow-up question. Okay, there is one. And this one is also from California. California, go ahead, please.
Yeah, hi. Yeah, I have got a 10 years multiple entry visa. And actually, when in India, the agent told me to mention 1 month.
Yeah, ma'am, I'm aware of all that. None of that changes what I just told you.
Yeah.
None of
But I got a ticket for three months, and I've also got a ticket to the East Coast.
Okay. Like I said, none of that
but
changes,
then
ma'am.
now
None of that,
I need
ma'am.
what?
Ma'am, none of that changes what I told you.
Okay, so I need to do an application.
Right. You can apply.
Yeah, and
go ahead.
Yeah.
Go ahead.
And what are the chances like?
Well, the truth of the matter is, it doesn't really, as a practical affair, it doesn't really amount to much. Why? Because for them to decide the application is going to take them 4, 5, 6 months. Okay. So,
okay. So legally I can stay here?
Right. So what I would have you do is apply for a 3-month extension, give a reason for it, give a reason for the change of mind, make sure you are truthful and genuine, and even though you don't receive the extension approval, leave within the time that you have asked for. Okay. So if
Okay, that is 3 months.
Haji, if you ask for 3 months, don't continue staying beyond the 3 months you asked
No.
for. Okay.
No.
And also,
And-
make sure you keep copies of your application, your receipt, and when the final decision comes, the final decision. Because next time when you come, they can ask you these questions.
Okay.
All right.
Yeah. And does my sponsor who's given me the letter need to give another letter to them supporting it?
I'm not sure that is even a requirement. I don't know why you got a letter. But let's say you got the letter. I don't know what your circumstances are. As long as it is a truthful reason, I don't care what the reason is, as long, for example, tourism. After all, you've traveled 7,000 miles and you want to spend extra time and you've got the time. I personally don't see a reason for anybody to sponsor your stay. Okay. But the government can ask you for evidence that you have money to support yourself.
Yeah.
Okay.
Yeah.
That's it.
Okay, so fine. So what is the cost would be, how much for this application?
You have to go online and look it up. I don't know what the amount is.
Okay,
I-539.
fine.
Okay.
Okay.
All right. Good luck.
Thank you so much.
You're welcome.
Thank you.
Bye-bye. Yeah, application fees and all I can't ever remember. Numbers are not my thing. Okay, folks. Anybody has any question, press *5. Anyone has any question, press *5. 1. Okay, 2. All right, so we've got 2 questions from, one is from California, the other one is from Illinois. And there's a third one now also from California. I'm going to go first to the person who joined us first. So this is California. California, go ahead, please. You are calling from...
Hello?
Yeah, go ahead. I can hear you, ma'am.
Yeah. Another question was, can I, since it's, the date for my departure is 6th of June, can I go to Canada and re-enter US after 2 weeks or so?
They will
okay?
not extend your stay that way normally. You can try,
Okay.
but they won't normally extend your stay like that. Okay.
Okay.
All right.
Fine. So I need to give an application. Fine.
Okay. Now let me go to Illinois. Illinois, go ahead, please.
Hi, Rajiv.
Hello.
Hey, so my question is somewhat related to one of the earlier questions on EAD and H1B. So my situation is that I have been working with EAD since 2012, and I've also been maintaining H1B. Like they kept renewing my H1B in parallel until I received my 485 adjustment of status. It's still not there. I'm still waiting for my priority date. But in between I had to change the employer on AC21. So now I am working with employer B, employer A, who was the original one who sponsored my initial EB2. And even employer B has continued to maintain my H1 status. So I've been on H1 extension from the very beginning, but I also have EAD. So my question is, if my 485 application is denied for any reason, will my H1 then continue to be valid? I'm always confused because people have said that H1B you should maintain just in case something were to happen. So your 485 application has a backup.
That's what we always recommend. That's what we always recommend. Keep your H1B in a healthy state so that if there's a problem with the 485, while your lawyers fight it out with the government on the 485, you can continue staying and working in USA.
Oh, okay. So it's while the appeals process going on. It's because ultimately the basis of this H1 is the
right. It's a fallback position in case something goes wrong. There's no appeal against a 485 denial. There is either a motion to reopen or a lawsuit. Okay.
Right, but I understand. But ultimately, if it's denied, my H1 also is becoming invalid, right?
No, not at all. Not at all. Absolutely not.
No?
H1 can still be valid, yes.
But until how long? I mean, how long can I extend if I don't have a EAD or 485 valid? At some point, can I still file H1? Or is it
that is a difficult question to answer. My suggestion would be that it can be extended for a very long time, if nothing else on a year-to-year basis. But I would have to know the grounds of the 485 denial before I can answer that question intelligently. So yes, you can still get H1B extensions. Okay.
Rajiv, I'm sorry, I couldn't hear you the last sentence.
Because your connection is, it looks like you're outside. It's very windy. So the answer is, look, I'm going to make it short. I've got to take another call. The answer is you can still get H1B extensions, okay? Even if the 485 is denied. Good luck.
Thanks.
All right. Hey guys, do me a favor. Try to call from a place where you can at least hear me and I can hear you. So if you are in a place that's very windy, it's the find some shelter. Okay. So let's just do the last question for the day. And this one is also from California. California, go ahead, please.
Hello?
Yes, go ahead.
Yeah, I have a question. Well, my case is that my wife, she tried to cross the border, and at that time she was pregnant, so I think she asked for voluntary like a type of deportation they gave her, so she went back into Mexico. But since it was the first time she tried to come here because it was pretty dangerous.
I'm going to stop you for 1 second. Sir, I'm going to stop you for 1 second. My apologies. We don't do any cases that involve political asylum or our work is very heavily focused on legal immigration, including, not that asylum is not legal, but include mostly about on employment-based and business-based immigration. I don't know. Last time I did an asylum case was 1993. So I haven't done any asylum cases for a very long time. Okay, sorry.
Okay. How about like I'm a permanent resident. Do you like can you ask something about citizenship?
Yes, of course. That's definitely our field.
Okay. I've been a permanent resident since 2010, and my green card is gonna expire in June of 2020.
Okay.
And I would like to apply for the citizenship before getting it renewed, so I don't have to pay that fee.
Sure.
But my question is, if the green card expires and I already submitted that citizenship, required to, for the test, is that do I have to renew my green card, or can you just wait for that for my interview?
Look at the USCIS questions on naturalization. There is a question there. Exactly this question that you asked. And if I remember correctly, what they say is that if there is more than 6 months remaining on your green card and you apply for naturalization, you do not have to apply for a renewal of the green card. But if there's less than 6 months remaining on your green card and you apply for naturalization, you do have to ask for an extension. Okay?
Okay. All right. So I guess I can.
Yeah.
Okay.
Good luck, sir.
So if I ask for okay, thank you, sir.
You're welcome. All right, folks, I have to run. We'll talk again in 2 weeks, hopefully. That's what we are planning to do. It's great talking with all of you, and good luck. Bye-bye. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time, every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com immigration.com, the period dot, and the application should show up.